raise a formal objection because I did not want to be accused of suppressing evidence.
One of the things I remember you mentioned, Senator, was the fact that you quite didn't believe the fact that he could easily just enter the La Vista subdivision. Because you said security is very, very strict in the subdivision.
That's right, yes. La Vista is a gated community, and the Homeowners Association imposed fees on the residents just to pay for the security guard. So the level of service that is expected by the residents is extremely high. No one is allowed into La Vista unless at the very moment that the visitor comes knocking at the entrance point, the guard first calls the homeowner that the visitor says he wants to call on, and affirms from the homeowner that they may be allowed inside. And so that always necessitates a wait of a few minutes, 10, 15 minutes sometimes.
And his story was, it was quite easy for him to just enter the subdivision. Does that necessarily mean that from there on you didn't believe his statement?
Not necessarily. Almost always, as a trial judge, I found, like all other trial judges, that no witness ever really just tells the entire falsehood or the entire truth. They always mix it up. So, at least on that point, I found him not worthy of credibility. And, you know, there is a saying, falsus in unum, falsus in omnibus. If you find that the witness has given false testimony on one major point, then the judge would be justified in throwing away the entire testimony, because the judge cannot be expected to try and pour over the testimony with a magnifying glass trying to determine which is false and which is true.
So if there's a salient point, you think that he has lied on, or that was, it seemed that he lied because of a particular salient point. You're saying that as a judge, as a former judge, your normal recourse would be to throw away the testimony.
The entire testimony will have to be disregarded. That's the rule.
Another point I wanted to raise with you, very important, Senator, is the fact that you were saying that Michelangelo Zusa's testimony came a year and a half after the La Vista payoff. Or at least a year and a half after the proclamation of the president.
A year and a half after he first started to campaign for her in January 2004, since the elections were in May 2004. So he already knew, if he is saying the truth, that there were dirty tricks being perpetrated or there were crimes being committed to ensure the re-election of the president, but he never told the public about it, or anyone else for that matter, until after about a year and a half had passed. And there is a decided case with the Supreme Court where it said you can delay your testimony by a few days, a few weeks, even a few months. But in that particular case, the Supreme Court said a delay of 1 year, 4 months means that the witness is fabricating testimony and is no longer credible. Now, in his case, he waited all of 1 year and 6 months, 1.5 years.
The Francisco, was it a Francisco case, ma'am? The Supreme Court ruling you were quoting?
I think People versus Bautista.
Bautista. Yes. And then you mentioned, all right, that has lapsed. At least the Supreme Court was saying after a year and 4 months, it seems quite incredible that you come up with a story like that. But in layman's terms, you were saying, ma'am, that you're going to have some sort of circumstantial evidence to corroborate. You have to have circumstantial evidence, even if that time period had lapsed. It
appears that Zusa's testimony is not direct testimony, but circumstantial or indirect testimony. He did not say, I saw President Arroyo hand the envelopes to the regional directors. He said merely, I went to Mrs. Arroyo's house, she sat down for dinner with us, she left, and after she left, her friend Lilia Pineda distributed money to all the election officials there. So, in effect, he is asking his listener to draw the conclusion that because the payoff was allegedly held in President Arroyo's house, then it must have taken place either with the knowledge and consent of the president. That is called circumstantial because it does not directly establish, but tends to establish another fact. Now, the rule on circumstantial evidence is that it can be sufficient for conviction, but there should be at least 2 items of circumstantial evidence. In this case, he has only 1, so he has to add, or the opposition has to add 1 more circumstantial evidence.
And the circumstantial evidence is the fact that he was there, and Baby Pineda had handed out envelopes when the president had joined them for dinner earlier. That's one circumstantial evidence you're saying?
That's right.
And there
yes.
should be at least two?
There should be at least two. Circumstantial is when, for example, there's a corpse, there's a fresh corpse here, and you're standing beside him, but you're not holding the gun, there are no nitrate marks on your fingers. That's circumstantial. That's why you cannot convict, because the standard is proof beyond reasonable doubt. So in the case of Suze's testimony, there is reasonable doubt by his account. Maybe Mrs. Pineda, assuming that Suze is correct, did it on her own without the knowledge and much less the consent of President Arroyo. But in any event, it comes from the mouth of Suze that this payoff allegedly took place after President Arroyo had left her house.
So it's still relatively weak, that's what you're saying?
That is correct.
Okay.
Yes.
The testimony, though, from the very beginning was questioned because of the fact of him being there. But they were linking it, Senator, to the fact that there were wetting money was used to bribe the COMELEC officials.
The mere fact that there is a tenuous connection, a very thin connection between alleged illegal wetting money and Mrs. Arroyo seems too forced. It's like a deus ex machina in the movies. It's like a god from a machine. You're trying too hard to put two entirely disparate, separate instances together. We have to take the totality of circumstances that are involved in this case, both the testimonies before and those that were contemporaneous with that of Suzy.
What about corroborating evidence, additional testimony that might prove Michelangelo Zuse's testimony?
Well, we'll have to wait for that. That's speculative, but if that is forthcoming, it might redeem his testimony after all. Right now, it's virtually worthless, because it is just his word. There's no other means of proving that he is correct. Plus, the reason why the Supreme Court and the Court of Appeals almost never overturn the ruling of a trial court on a finding of fact is that the trial court had the benefit of watching the demeanor of the witness as he testified. That's why they never change a finding at trial level. I think that in this case, since Suzy appeared on TV, each one of us who were watching him can draw our own conclusions whether the man is trustworthy or not.
What was your conclusion?
He's not.
He's not trustworthy
because
at all.
of his
What was wrong with his demeanor? As a judge, what did you see that seemed to be wrong?
Well, he seemed to take everything in jocular spirit.
Yeah.
Normally, a witness would be a little bit nervous, even if he is totally trustworthy and reliable, because he has no experience testifying. Most people break out in a sweat. Doctors, lawyers, doctors testifying about an illness for which they have no liability whatsoever. But in his case, he was just too nonchalant about the whole case. And even if he was confronted with maybe what we could call provocative language, he did not assume the proper response, at least in his facial expressions. It's as if he was just ready to let everything roll down his back.
What about the other school of thought, Madam Senator, that you may act, your demeanor may be a certain way because you're telling the truth, because you're so sure of yourself, medyo parang cocky. You can be a bit cocky sometimes even because you are not lying. You don't break out into a sweat.
No, that is not the accepted theory in trial practice. Normally, the witness is too eager. He is either very timid with the judge simply because of unfamiliarity, or he is too eager to please the judge and watches for cues. But he is certainly not arrogant or prideful when he testifies, generally. And then the witness, of course, as a basic rule, will look you in the eye. If the judge asks a question, which is sometimes allowed, he can interfere in the examination or cross-examination and himself ask a question, and the witness turns. You can tell just from the way that the witness glances or looks at the judge whether he's telling the truth or not.
Was he looking at you straight in your eyes, straight to your eyes?
No. He was, I think, scanning the whole table of the senators. In my case, for example, I am looking you straight in the eye, an occupation that I would like to do all afternoon because you are so easy on the eyes, and I admire your jet set tan, but we are not in a courtroom, so has no relevance to the
But what do you
issue.
do as a senator, Madam Senator? I mean, you give us your experiences as a judge. That is yours. You're saying his demeanor seemed quite strange for someone who would have been telling the truth.
Right.
But as a senator, with regards to the testimony he's given to you, the La Vista payoff, maybe wasn't there, did you see an angle of spontaneity somehow in his answering the senator's queries?
No, in fact, he admitted that at the moment or during that date, which is unspecified, apparently people already forgot what the exact date is, but in any event, he admitted, one, that on that date, when the election officials were allegedly taken as a group to La Vista, it happened that they had all been summoned to Manila to a certain hotel because they were going to hold an organizational meeting of an association of election officials. So there we can already have ground for discounting his testimony that people were called from different parts of the Philippines just to come and receive money as a bribe. Secondly, it goes against human experience that if a candidate wants to bribe an election official, she will plan to do so in the company of all other officials who can all serve as witnesses. If that were, in the event, if that were the strategy of Mrs. Arroyo, then she would have sent trusted messengers to each of these supervisors in their provinces of jurisdiction, so that there would only be her messenger and the election official giving and accepting the bribe. There would be no witnesses. It just runs against human nature.
So if you were to commit a crime, you'd do it with the least people around you?
Of course, as much as possible. You know, the best test of credibility is not a formula or a rule. The Supreme Court has repeated over and over, the best test of credibility is common knowledge, observation, experience of mankind.
Instinct, you use that a lot? Did you use that a lot?
Nah, judges don't work on instinct. They work on jurisprudence. What did the Supreme Court say in a similar case? We don't question anymore the philosophy of the decided case. We go by precedent. That is why to a lawyer and to a trial judge, what the Supreme Court has done in a prior similar case is extremely, extremely important. The power of precedent is overwhelming in law.
Right. That's why you use the case of
That's
Bautista.
correct, yes.
All right. We will discuss Richard Garcia's press conference yesterday with Senator Miriam Defensor Santiago after the break. Stay with us. We're still joined in the studio by Senator Miriam Defensor Santiago. Yesterday, Richard Garcia had a press conference, and basically, I was confused in the beginning, Senator. I'm not sure if you watched it in its entirety.
No, I didn't.
Okay, in the beginning, you didn't know where he was going to go with his statements. So he was with Ding Santos. He was a mayoralty candidate 4 times in Pasay City, and eventually, as the press conference went on, he said, I'm not recanting any of the statements made. I made during the Senate wetting probe. But what I'm saying is, I have no knowledge of the first family being involved in wetting operations. And he mentions the handiwork of some opposition solons behind his coming out during the Senate wetting probe. How do you see that? Is there going to be some sort? I mean, it's not a recantation. He's just saying that I didn't say really Lion King. I didn't mean, I have no personal knowledge that there was a Iggy Arroyo or a Mikey Arroyo that was involved in wetting payoffs.
In effect, I think it would be fair to say that in its totality, his press conference on TV yesterday meant that he did not want to recant any of his testimony concerning wetting operations, how it is done, who are the people who facilitate it contrary to law, and what are the hierarchies, and so on. These structural or hierarchical stories that he told us, he does not want to change. But in effect, he is saying, I do not recant my testimony that my boss, it was my boss who told me that members of the presidential family were on the take. So he was not recanting his testimony, that he was only offering hearsay evidence. I simply heard it from another person. So if you affirm hearsay testimony, what happens is that you've simply repeated the hearsay. And the rules of court provide that hearsay testimony is not only worthless, it's not even admissible
in court.
So the failure to recant does not in any event produce any legal consequences insofar as the findings concerning the Arroyo family are concerned. In fact, it is even an asset now to the president's lawyers because they can point to the fact that the witness on 2 separate occasions indicated that he had no personal knowledge but was simply passing along what was told to him. In other words, hearsay evidence. And the mere fact that he apologized to the president is the more important aspect of his testimony in light of the Supreme Court ruling that when a party to a criminal case apologizes to another party, that in effect is the equivalent of an offer to compromise. And an offer to compromise in a criminal case, said the Supreme Court, is proof of guilt. Once you apologize, in effect, you admit that you're guilty. So, in effect, that was his way of admitting that he had committed perjury if he had given the impression that the president's family were on the take, or that her family had received part of the illegal hueteng payoffs. So, if we apply jurisprudence, then what he said yesterday was definitely an asset for the president's defense.
How do you answer, though, some people questioning Richard Garcia saying, I apologize to the president, hindi ko alam na, short of saying na dadating dito ang ginawa ko, how can you not know something like that? How can you not know na hindi mo masasaktan ng presidente by implicating the first family to hueteng operations?
Alam mo kasi, hindi naman siya yata college graduate, is not a professional.
But it's common sense, isn't it,
No,
Senator?
siguro sinabihan siya, gusto lang namin talaga mahinto ang hueteng. Because remember, the gravamen, the very object of the hearing is not to find criminal liability among public officials. That is only incidental.
Right.
The main thrust of the Senate hearing is to find out whether we should legalize hueteng or not. Pass a law and make it legal. That is why it is called an inquiry in aid of legislation. Kaya siguro pinagsabihan siya, ikwento mo nga ang paraan ng hueteng para maintindihan ng mga senador kung dapat ba gawin na nating legal ito o manatili itong kriminal. Kaya akala niya yun lang, magiging guro siya on how hueteng is actually perpetrated. We were all fixed to our seats because we were fascinated by all of these tidbits from the underworld. But sigurong ibig niyang sabihin ay, hindi ko inasahan na dadalhin pala ang pagkatestigo ko na masangkot ang pamilya ng presidente. Hindi iyan ang layunin ko, pero yun ang nangyari, kaya talagang, how do you say, I am very sorry at the outcome.
But it came straight from his mouth. He said Lion King, and then he said si Congressman Mikey Arroyo. Sa kanya nang galing yun, Senator.
All right. My memory is not clear there, but if that is the case, I remember clearly that during the hearing, he never claimed that he gave payoff money to either the father or the son, the husband or the son of the president. He said, I was told that the money, part of the money I was giving would be given to them. So it was always hearsay, always on that basis.
So it doesn't matter that you say, at dapat pupunta kay Mikey Arroyo. Because it's still hearsay.
It's hearsay.
There's no strong evidence, really. There's no eyewitness account to that.
That's right. And perhaps that is the reason why Suzy had to be produced. Because if the opposition had been consulting trial lawyers, they would have known that they still had nothing on the president, since hearsay is not even admissible. So now they had to connect a direct testimony from as an alleged eyewitness to the hueteng money. That is why there is this forced attempt to connect hueteng through this La Vista dinner.
What about corroborating evidence on the, what we can call the apology of Richard Garcia to the president. We can't call it, he didn't recant, but he apologized to the president, linking the first family. But he says Sandra Cam and Boy Mayor, I don't know where you're going with this. Parang sinasabi niya, parang ako, nagsasabi na ako ng totoo, paano kayo? What about corroborating evidence? Are you going to believe, do you believe Richard Garcia now, or you will tend to believe him more if isa sa kanila ay bumaliktad o magsabi ng totoo?
Doon sa mga nabanggit niyang mga kasamahan niya, ay di mas magaling sana kung merong corroborating testimony from his colleagues. But on his own, unlike circumstantial evidence, his own direct testimony is sufficient to be able to establish the fact he is arguing that he has no personal knowledge that President Arroyo or her family received payoffs from illegal hueting. That is the fact as it stands. Those two other witnesses similarly gave evidence that was also hearsay in nature. So we just have a lot of hearsay evidence. That's why they had to produce Suze, so that he could claim to be a direct witness. But the best that he could do was to say, I went to her house, I had dinner with her, but she left the house, and that's when another person gave us the money.
Suze is a direct witness. You would describe Suze as a direct witness.
He's not even a direct witness. He is presenting circumstantial evidence. All the others before him were presenting hearsay evidence, totally worthless. Now, Suze is giving circumstantial evidence, but it has no value unless it is corroborated by another piece of circumstantial evidence.
You had a press release, Madam Senator, saying that there could be two crimes that opposition senators could be charged for. Number one is the crime of inciting to sedition, and the second is the crime of offering false testimony and evidence. I can understand the crime of offering false testimony and evidence if it's true, but what about inciting to sedition?
That's if what he is saying is true.
Richard Garcia.
Yes, we're hypothesizing. Inciting to evidence is committed not only by going out in public and calling on people to use illegal means to overthrow the government, but it can also be committed just by speaking to another person, inciting him or leading him on or steering him up so that he will feel impelled to throw off the existing government by illegal means. And this illegal means will refer in this particular instance to the perjured testimony in a Senate hearing.
Saying that the first family is involved in weapon.
That's right. Halimbawa mo, lahat sinabi ni Richard Garcia doon sa hotel kung saan daw nagkita sila ng mga senador. Ganito, sir, ang mga patakaran at ang mga paraan dyan sa illegal hueteng. Ngayon, hindi ko alam kung may partisipasyon itong Arroyo dahil yun lang ang sabi sa akin. Pero ako mismo, wala akong alam dyan. Eh, kung halimbawa mo, tinuruan siya, idagdag mo na lang na nakita mo o kaya binigay mo. O kung ginawa niya iyon, then the senator who coaches him in that manner would be guilty not only of immoral conduct for which he should be hailed before the Senate Ethics Committee, but he would be guilty of nothing less than a crime itself, the crime of presenting false evidence or a false witness.
And eventually inciting to sedition also?
That could be a separate crime.
And we're referring to Senator Ping Lacson because basically he had repeated the name of Senator Ping Lacson. Parang sinabi niya si Senator Ping Lacson ang nag-coach sa kanya eh.
Oo, yun ang allegation niya, no? Ngayon, ang hindi natin maintindihan kung inaamin nga ni Senator Lacson na nag-usap sila. Kasi wala kaming alam sa Senado na si Senator Lacson, meron pala siyang papel dito. Ang pagkaalam namin, pinipresenta lang ni Archbishop Cruz. Because before the start of the hearing, Archbishop said, I have a witness, can I call him? Pero hindi man sinabi ni Archbishop na usap sila ng testigo noon. Sana kung sa umpisa pa lang, sinabi ni Senator Lacson at ni Archbishop Cruz, we want to make it of record or we want to manifest that we have talked to this witness, but only to counsel him about his rights and about his duties under oath. Then these suspicions would be laid to rest immediately. But it took the press conference of Mr. Garcia yesterday for these alleged facts to surface. So, of course, there's already a lot of suspicion percolating in the minds of all the viewers.
Would you like to invite, if given the chance, Richard Garcia to the Senate wetting probe?
He has already testified many times there. He's been testifying for about 4 or 5 times. My position is this: there are so many loose ends in our wetting hearings, but I would rather that we terminated the hearings because I am afraid we might be anticipating or duplicating what will be taking place in the impeachment proceedings in the House Justice Committee, and it will not bode well for the Congress that one chamber is contradicting another chamber.
Especially if you have different findings.
That's correct.
Okay. But in the event, though, I think Richard Garcia has already said that he's not very willing to appear anymore. It's actually hard for him because yesterday, Senator Ping Lacson, he didn't categorically say, all he said was his apologies, Madam Senator, to Richard Garcia for the possible lapse in providing security for Richard Garcia, which the Senate was supposed to be providing.
I see.
Because you gave him immunity, didn't you?
Yes, but we mean legal immunity from criminal prosecution unless the witness makes a request. The Senate normally does not provide military security.
What would a senator do when another senator is being accused of eventually even being charged with falsehood or false testimony and evidence and inciting to sedition? I mean, that is your colleague in the upper house.
Well, normally the complaint would be filed in the office of the ombudsman, and so he enjoys the presumption of innocence, so we'll just greet him and deal with him in the session hall on the presumption that he is innocent. The ombudsman will have to carry out the legal process indicated in the law books.
Okay, what is in store for the Senate in the next couple of days?
Well, the sad thing for the senators is that they cannot go abroad because they would be accused of abandonment of office or of frivolity. So at the very least, that might be good news for the public in general, because you know that the practice in the Senate is that almost every month we have a break of at least a week so that they can go abroad. So now they can't. Well, in the Senate, there is a very almost palpable atmosphere of anticipation. We cannot concentrate on the quotidian, the day-to-day affairs of legislation, because we know that major legislation, not only the budget, but maybe impeachment itself, is in the offing. So we're on pins and needles. We're ready to jump out of our skins.
You're waiting for developments then again.
That's right.
In the House of Representatives. I think the House Justice Committee will begin deliberations on the merits of the impeachment complaint come Wednesday.
Yes.
And then from then on, we move forward, or it stops.
That is correct.
All right.
You're correct.
Senator
Thank you.
Defensor Santiago, ma'am, thanks for joining us this afternoon.